All right, we're back. Thank you, everybody, for dialing into today's webinar. We're going to go ahead and get started, and remaining folks can trickle in as they can. But we're live, and thanks again for joining. This is the California Workers' Compensation Review Preview. And if you have, we're going to try to cover a fair amount of content here, but keep this to 60 minutes if we can. Respect everybody's time. If you have a question, there is a question module or a dialog box that you should be able to see on your control panel on your screen as a webinar attendee. If you have a question, go ahead and just type it in to that question module, and we will try to answer as many questions as we can as at the end of the presentation part of this. And if we can't answer the question, please feel free to follow up with any of the presenting organizations after the fact, but we will try to get to as many questions as possible. So with that, we're going to kick it off here. You've got 3 presenters. We'll all talk very briefly about ourselves and our organizations, but this is Jerry Azevedo. I'm with the Workers' Compensation Action Network. We're also joined by Jeremy Mers of the California Chamber of Commerce and Jason Schmelzer with California Coalition on Workers' Compensation. And we'll talk just briefly about each organization, starting with Jason and CCWC.
Morning, folks. This is Jason Schmelzer with the California Coalition on Workers' Compensation. We are obviously a statewide association of employers focused singularly on the workers' compensation issue in the state of California. We do a lot of advocacy on legislation, regulations, and just big picture policy. We've got a great presence here in Sacramento. And we've been going strong for over 25 years as an organization. We also do an incredible amount of educational outreach. We run what I think is the best workers' comp conference in the state of California every year in July. We do an annual legislative education day. Obviously, we do some webinars. And for those of you who have not been to our website, it no longer looks like it came from the 90s. We just finished a fancy update on that, so I encourage you to check it out.
Good morning, everyone. It's Jeremy Mers, California Chamber of Commerce. CalChamber is the largest pro-business advocacy group in the state. We have about 13,000 members, and our members employ nearly 1/3 of all California private employees. From a work comp perspective, we break down a lot like the market. About 1/3 of our membership is self-insured, 2/3 are insured, and 75% of our membership is small business, less than 100 employees. We have a robust advocacy operation. I'm on a team of 7 lobbyists. We track about 3,000 bills and actively engage and/or position on about 450 bills every year. The issues we cover run the gamut from employment, tax, environment, energy, comp, unemployment insurance, privacy. It goes on and on. We come out with our list of job killers every year, which is where we identify and label kind of what we consider the worst of the worst bills for California employers and the California's business climate. This is usually between 20 and 30 bills every year, and that constitutes less than 1% of bills introduced. And we also support pro-job candidates through our political action committees. And then we have a product side as well, where we produce employment law materials, compliance posters, pamphlets. So that's what the CalChamber does.
And again, this is Jerry Azevedo on behalf of the Workers' Compensation Action Network. And I won't read all the words on the slide here because, frankly, probably a lot of them will look familiar from some of the things CCWC does. But a good way to think about it is that we are certainly complementary organizations. CCWC is certainly engaged in direct advocacy in the Capitol and a number of other activities, whereas WCAN, our focus is really on trying to work with the media, work with members of the business community, the broker community, employer insurers broadly to make sure that we're tracking trends, getting information out there. We do our best to engage in grassroots advocacy at the local level and here in Sacramento through the Collaborative Ledge Day. We're active on social media and online. We tend to function as an information bureau and kind of a place to craft an opinion and messaging about what it is that's going on in the system and how that affects folks who are particularly responsible for paying the bills, but also how it affects everyone who's affected by the system, whether you're an employer or an injured worker. So with that, we're going to dive right into the content of the webinar today. Sort of as advertised, we're going to do some review, and we're going to do some preview in today's webinar. The saying goes, past is prologue, especially when it comes to workers' comp, which tends to be pretty cyclical in nature. And the saying is especially true when you think about California and workers' comp reforms, which tend to occur at fairly regular intervals, interspliced with periods of turmoil and or crisis. So we think looking back at the political developments and emerging system trends over the past year will give us the best insight we can into how the system will continue to be shaped and take shape next year and beyond. So specifically, we're going to review the political landscape, changes in the electoral environment coming out of the elections, do a very high-level look at some key developments and trends in the system. Not going to have time or capacity to do a real deep dive, but look at it briefly, and then finally look at the results from the 2014 legislative session and do a little bit of prognosticating for what we see coming down the road next year. So with that, I'll turn it over to the remainder of the team to talk about political developments in review.
Thanks, Jerry. So first up, Jason and I are going to, again, just briefly cover the political climate in Sacramento right now, touch on the 2014 election, give a little overview of the workers' compensation power structure, and kind of look at how that will affect or potentially affect workers' compensation legislation and policy over the next few years.
All right. So landscape assessment in Sacramento. And the reason that we touch on the politics and we're also dealing with the policy is, what needs to be done in the workers' compensation system from an employer perspective is probably pretty clear to all of you and certainly to us. But when we're across the street in the legislature and dealing with regulators, you have to remember that we've got 120 individuals in the legislature that have their own experiences, they're individuals with opinions, and in order to advance the policy, we need to understand what's going on there. All right, so big picture landscape. I think if you talk to any lobbyist in the state of California, they'll tell you that the most important thing to understand is that Governor Brown is in firm control of what's going on. There have been periods of time where the legislature was really at the forefront. If you think during the Schwarzenegger administration, et cetera, it was really the legislature that was driving the press, driving the conversation. Now it's absolutely Governor Brown, and in the statewide offices, the Democrats just don't have the governorship. They control all 8 statewide offices. So it's a very democratically controlled political landscape in the state of California. That's not just true for statewide offices, but also with respect to the state legislature. And there's some key changes that have occurred over the past several years that we'll be talking about in a little bit more detail. One is the changes in term limits. Putting simply, we'll go into it later, legislators are going to be around for a little while longer, which from my perspective at least is a very good thing. They're going to have a longer period of time to learn policy and then take what they learn and apply it to the policy-making process. There's some changes in the budget, politics, and leadership and committee chairmanships that we'll get into. If you look at the Assembly and the Senate, we provide a very brief breakdown of the partisan makeup. In the Assembly, there are 52 Democrats, 28 Republicans, and out of that population, 26 of the 80 members in the legislature, or in the Assembly, excuse me, are freshmen. They're brand new to the legislature this year. In the state Senate, there are 26 Democrats, 14 Republicans, 3 vacancies soon, folks moving on to Congress. And out of that population, there are 10 folks that are new to the Senate.
So Governor Jerry Brown, as Jason said, right now is the term adult in the room, most powerful governor in recent memory, certainly. He was just recently elected to his 4th term as governor, and that's a record. He received 60% of the vote in November, and he did that in a historically low turnout and without doing much campaigning at all. In fact, he basically only campaigned for some ballot measures, or the water bonds and the rainy day fund, but he really didn't campaign for himself, and he still received 60% of the vote. He's, again, arguably California's most powerful governor. His party overwhelmingly controls the legislature, and his party, as Jason also alluded to, or the legislature itself, is fairly new and inexperienced. Governor Brown is not. He has vast amounts of experience in California politics and government, spanning nearly 6 decades at this point, and he knows all levels of government. He served as everything from community college trustee, Secretary of State, Attorney General, Mayor of Oakland, and Governor for over a decade. He has high favorables right now. The California voters like him, think he's doing a good job. He has a lot of money in the bank to support whatever measures, or I guess oppose whatever measures or issues he wants to take on in his 4th term. A lot of that, again, is due to the fact he did not have to spend campaign funds for his reelection. And kind of the other dynamic that you really see, or at least pundits are projecting, is he doesn't really have anything left to lose. His decisions will not have a ton of political pressure that you traditionally see, where a governor would be looking to ascend to the next office. You hear rumors now and again about, you'll see somebody get bored and write the article about him making another run for president. I don't think that anyone really expects that. People talked about him going back to mayor of Oakland, but in reality right now, it's just seen as kind of being untethered and focusing on this last term and some legacy projects. And to that end, he's had a very impressive record so far. He's gotten pretty much everything that he's focused on and really taken on. He's gotten it done during his 3rd term, including balancing a budget which had major deficits, passing Prop 30 tax increases, eliminating enterprise zones and redevelopment agencies, increasing the minimum wage. The list goes on. But certainly one of those was the workers' compensation reform, SB 863. He was the reason this reform passed. He carried it kind of across the goal line when in the last week of the 2012 session. So it's a good thing for us. He's invested in its success and seeing it through. And this includes full implementation, protecting the system from attacks, and making sure that legislation that comes to his desk really fits within the confines of a healthy workers' compensation system.
I'd add one more thing, this is Jason, about Governor Brown, which is he has an excellent signature and veto record on legislation related to workers' compensation in his most recent term as governor. I think there's been one bill from our perspective where he didn't quite hit the mark, but again, that's a debatable one.
This next slide shows the 8 statewide elected officials, and as Jason said, the takeaway from this really is these are all Democrats, and generally, I don't know generally, but from this pool, you're going to see some potential candidates for governor in 2018. There are no Republicans up here, so it kind of indicates the direction of the governor's office going forward. Certainly candidates can come out from outside of this group, but you hear the names, Lieutenant Governor Gavin Newsom and Attorney General Kamala Harris often in conversation about who's running for governor in 2018. And these folks certainly have an advantage to the extent that they've run statewide campaigns, they've built statewide networks and coalitions, they have the know-how, so it just gives you an idea of the direction of where California may be headed. The one that, aside from Governor Brown, that really has a nexus to the work comp system is going to be Insurance Commissioner Dave Jones, who is in the upper right-hand corner on the screen, and he, of course, is in charge of the Department of Insurance, which oversees and regulates the insurance industry, including work comp insurers, and he, in consultation with the WCIRB, sets the advisory pure premium rate.
So a little bit more about the legislature real quick. We already talked about the makeup. You have the Assembly, 80 members, the Senate, 40 members. In the Assembly, they serve 2-year terms, kind of like those folks in Congress. In the Senate, they have 4-year terms. So there's been some changes to term limits, which we talked about earlier. Term limits were originally passed in 1990, Prop 140. It essentially limited folks to 3 terms in the Assembly, or a total of 6 years, and 2 terms in the Senate for a total of 8 years. Add those 2 up, you had 14 years. Problem was is that by the time somebody got through 6 years in the Assembly, they were just starting to figure out what was going on, and they took that knowledge and then left with it. And then you had more freshmen that came in, and it didn't lead to a lot of institutional memory in the legislature. I actually refer to it as the Lobbyist Full Employment Act. So thank you. Then came Prop 28 in 2012, overwhelmingly supported by the electorate. Now, technically, it shortens the total number of years that a legislator can spend in office, but it allows them to spend it in one house. It doesn't matter where the time is spent. So an Assembly member that would have termed out after 6 years and wasn't moving on to the Senate can now stay in the Assembly for another 6 years, utilize that knowledge and experience that they've had from the first 3 terms in office and stick around. You're going to see chairmen or chairs of committees last longer. I think you're going to see some of the institutional knowledge and power shift from the third house or the lobbyists and staff back to members of the legislature. All right, so the next slide is on legislative leadership. These are the 4 folks that really drive the conversation in the legislature. On the Assembly, you have Speaker Toni Atkins, who is kind of a short-term speaker. She's going to term out in 2016, so there's already a lot of conversation about who's going to follow her. She's from down in the San Diego area. The minority leader in the Assembly is Kristen Olson. She's out of the Central Valley, Modesto specifically, and she terms out in 2016 as well. In the Senate, we have newly elected pro tem, Kevin De Leon, terms out 2018. He is the author of SB 863. He's the legislator that had his name on the bill when it was passed. I can't say that he's probably too deep into the workers' compensation weeds, but he has obviously demonstrated a willingness to engage when needed. So that's something that should be on your radar. Finally, again, Bob Huff, minority leader in the Senate, terms out in 2016. He's from down in the Fullerton area. And these are just kind of the personalities that are out there that we wanted to make you aware of.
So this slide goes over the key decision makers in California's workers' compensation policy, the executive, and then the legislative branch as well. So we've discussed Governor Brown, and he ultimately, I think, is the most powerful decision maker with work comp. What he says goes right now. But on that line, you start with Division of Workers' Compensation Director Desi Overpeck and DIR Director Christine Baker. Of course, those 2 both oversee the regulatory body that governs workers' compensation. And above them is Labor Secretary David Lanier. David Lanier was confirmed this year as the Labor Secretary. He too, Jason referred to De Leon's connection with, Senator De Leon's connection with SB 863. David Lanier was in the governor's office as a legislative secretary at the time, and really was instrumental in helping get SB 863 passed. So he knows it, he wants it to succeed. He too, like Governor Brown, I think has ownership over this. Again, a good thing as far as executing SB 863. On the Senate, Jason covered Senate Pro Tem Kevin De Leon. Below him, there's a blank right now, and that's where the Senate Labor and Industrial Relations Chair will go. He or she has yet to be named. There's an expectation that the chair will be named in the next couple of weeks, certainly before January. But this is the committee where all workers' compensation bills go in the Senate. And then the consultants for that committee, one is Gideon Baum, and he writes all of the analysis for all the bills. They go through that committee. He also has a lot of institutional knowledge of how that committee is run in the work comp system itself. He's been through, I think, now 4 chairs, so a very valuable resource. And then on the Republican side, with that committee, you have Corey Botts, who fills a similar role for the Republicans to serve on the committee. On the Assembly side, again, Speaker Tony Atkins, but of real significance is the new chair, Assemblymember Tom Daly. He is from Anaheim, and he is going to be entering his 2nd term as an Assembly member, so he's part of what we call the sophomore class. Jason talked about the new dynamic with term limits. Assemblymember Daly potentially could serve in this position for 10 years, which we think is a positive thing. Workers' comp is obviously a very complex topic, and with the rotating doors of chairs, it hasn't really given anyone time to become educated completely on the topic. So Assemblymember Daly could become a dean, if you will, on workers' compensation policy as chair of the committee. And then his consultant is Mark Rakich.
Okay, so now that we've got kind of an idea of what's going on politically, we want to touch very quickly on the 2014 election cycle. Now, listen, I don't think anything that happens in this election cycle, the results are going to change much on the politics of workers' comp. But there were a bunch of seats that were very competitive. As we'll talk about in a minute, there was historically low turnout in the state of California, which typically favors Republican candidates in the state. So the big picture is we had some really strange things happen. The Assembly Democrats lost 4 seats, net 4 seats, in pretty fantastic form. Again, mostly attributable to the low turnout. I think there's an expectation that they gained some of those back in 2016. The Senate was down 1 seat. I'll say one interesting thing, which is if you look at 80-39, Bocanegra versus Lopez, I think there's a big takeaway from this. Raul Bocanegra is widely considered, was going to be the next speaker, or was at least, in the top 2 or 3 names that was out there. Very politically astute, very well liked on both sides of the aisle. He was a player, and he had raised a ton of money, and he had beat Ms. Lopez by, I want to say, 40 points in the primary. Well, he spent a lot of time doing what people who want to be speaker do, which is helping other people in their races because he felt safe in his own district. Well, Patty Lopez, who is now a sitting member of the California State Assembly, a self-described stay-at-home mother that raised her campaign funds by selling tamales, raised $10,000 total and took out Raul Bocanegra, potentially the next speaker, who had $800,000 in the bank. So there's a lesson being learned by a lot of legislators about focusing on your district. There could be a takeaway here from the workers' comp world. It's an opportunity for organizations like the Chamber and CCWC and WCAN to really start making some district connections for legislators on the workers' compensation issue and make sure that they understand that they need to be paying attention to this issue in their district.
So our last slide before we jump into policy and turn it, or the state of the system, I guess, turn it over to Jerry, is the 2014 election cycle. Jason made some broad points, which was that this was historically low turnout. Some people are thinking that this election will at least temporarily kind of be a one-off and not predictive of future elections, at least 2016. So what you have is the 2014 general election had about 40% turnout. And this, as compared to 2010, is 20 points lower. That was a 60% turnout election. And then if you look at the 2014 primary, it was only 25% of the voters turned out to vote. So, the big takeaways from the low turnout are, as Jason alluded to, explains why the Democrats lost the supermajority, which is they had 2/3 of both houses were Democrat. It dipped under that now. But one of the main reasons for that is because of the low voter turnout. There may be less Republicans, but they seem to turn out more in low voter elections, and it favors Republicans to some degree. Though notably, none of the statewide offices shifted Republican. They all remain Democrat. Also, it's not likely to repeat in 2016. That will be a presidential election with no incumbent, so it will be a very high-profile presidential election. I guess they all are, but it's predicted that, again, we'll see high turnout, and it won't look anything like 2014. The other kind of takeaway is there will be potentially a large number of ballot measures. The way you qualify a ballot measure is by collecting signatures. The threshold of signatures is determined by the number of voters who voted in the last gubernatorial election. With this low turnout, it makes that number lower and getting ballot measures qualified a lot easier and less expensive. So there's a chance you'll see a number of ballot measures floated, whether they're ideas or whether they're actually put on the ballot. And you're hearing around Sacramento a whole host of ideas from tax reform, pension reform, marijuana legalization. I mean, the list goes on. So we'll see how that all develops.
So we're going to do kind of our high-level look at the system in review. This is Jerry Azevedo back on the phone here from WCAN. So if you have any problem with the next set of slides, you can blame me. There are multi-day conferences and reams of paper that get published looking at the system every year. So we don't have time to do that, but I think what we're going to try to do is look at sort of the latest reports and bulletins that we can get our hands on and look at the system basically from 3 vantage points. 1, how do we perform relative to other states, kind of the national benchmark look. 2, how is California's system performing over time? Which way are things going? And 3, how the changes that were embodied in SB 863 are likely to impact both our competitiveness with other states and our performance over time as we look ahead and go forward. So as most of you know, California reclaimed its dubious honor of being ranked the most expensive state for workers' comp in the nation. It wasn't even close. You can see we had to get our own color even to be on the map with the other states. What we know is that California had slipped down to the meatier part of the pack back in 2008 and even in 2010, where we were appearing to become a little bit more competitive. But 2 things happened. Our costs were going up, and costs in other states, meanwhile, particularly some that had passed some significant cost reduction legislative reforms, took effect. So our reemergence as the #1 most expensive state had a lot to do with both costs going up here and costs going down in some other states. We basically have 3 reasons why we think that's the case. There are a lot of reasons. California system's complex. It's very large. It's more than $20 billion system annually and going up. But we think it boils down to 3 things that make us a high cost differential, and this is in no particular order. The first is our high frequency. California sees a higher rate of claims than other states. It's kind of a California conundrum. We're not inherently more dangerous. We don't have more hazardous occupational sites than other states, yet we see more claims. Our rate of injury, rate of claim anyway, for 1,000 workers is 46% higher than the national median. This conundrum is even a little more perplexing when we look at what's happening over time and nationally, where claim frequency has been declining literally for decades. Usually that includes California, but there was a national aberration about 2010 when claims went up. But since then, claims nationally continued their downward trend, yet in California, continue to see claim frequency going up. And when we say it's a California problem, in this case, it actually really centers around the Los Angeles region and could be dubbed kind of the Los Angeles problem. Actually, if we were able to eliminate LA from California's workers' comp system, California's trends would look a lot more like they do nationally in other states, at least as it relates to claim frequency. So basically, we're dealing with more claims in the California system. And more claims overall is problematic, but it also, because that places strain on the resources of the system and it increases costs. But What's even more problematic is the type of claims that California sees more of. As we know, a lot of claims are relatively simple and straightforward. It's a modest amount of medical treatment. Maybe there's some lost time benefits, maybe there's not. But that's a lot of what comes through California's system. But California also sees a much higher rate of claims that result in permanent disability than you would see on sort of a national average scale. Almost half of all of the claims in California that have some amount of lost time benefits result in permanent disability, which is kind of an astounding figure. But these claims tend to be more complex. They involve longer-term medical treatment. They frequently involve litigation. So all of these things drive up costs. So it's not just the number of claims, but it's the type of claims that we see. And if PD claims are more costly and complex and litigated, cumulative trauma claims are even more so. And we can see that cumulative trauma, or sometimes they're called non-specific claims, tend to have all those complexity features of PD claims, and these have taken up an increasing portion of our claims in California. It's nearly doubled since 2005. The reasons why are not totally clear, even to real smart folks that look at this system a lot, but it's certainly something that is notable on a trend line. So that's sort of more claims is number one. The second big reason is our medical costs are more expensive. We're the third highest state for medical costs per claim. We saw a significant uptick in medical costs, both on a per claim and an aggregate basis between about 2004 and 2011. And those medical costs per claim were up about 60% in that time period. So we've seen that moderate a little bit over the last couple of years, but certainly when you think about California and being a high-cost state, medical treatment costs are a big part of that mix. And so what we would point to as the third big ticket item is California's expense burden, which is kind of a technical way of saying our system is extremely inefficient. In 2012, which these numbers are from, we spent about a third of all the system dollars on expenses, which sometimes are, is a long list of items, but sometimes these are referred to as frictional costs, which makes some sense when you consider that we spent well more than $1 billion on legal fees to sort of fight about and adjudicate permanent disability ratings, medical treatment disputes, et cetera. So the bottom line, it just takes us a lot more money to deliver a dollar of benefit to the injured worker. So sort of in that context, along came SB 863 in 2012, sort of looking at the fact that California was a high-cost, highly inefficient system that seemed to be getting worse, frankly, by the month back in that year. So we saw the state legislature, and particularly Governor Brown, step in. Interestingly, while employers were complaining about the increasing costs, others were taking real issue and had been for a number of years about inadequate benefits, which is just another underscores how inefficient our system is. So SB 863, sort of at the heart of it, or one of its hearts, is a significant benefit increase, more than $1 billion plowed into PD benefits when you consider both the direct costs and the increase in claims. So, but to their credit, rather than exacerbating that problem of high costs with higher benefit structure, SB 863 was looking at funding those benefits by reallocating system dollars specifically away from certain vendors, and away from frictional costs. So this was a long list of process changes that were essentially intended to reduce disputes and delay, as well as some measures that were intended to clamp down on some very specific and obvious abuses like pass-throughs on spinal hardware, liens, et cetera. So, looking at how all those things shake out, some thought, in the early projections that the end result could be a net savings of about 1%, or about $200 million annually. But we'll talk about where that sits briefly. So, when we say looking at 2 out of 3 cost drivers, really what SB 863 was trying to do is reduce that administrative burden, or that inefficiency, by making things operate more efficiently, more objectively, and then figure out what it is that we can do to get the right kind of high-quality medical treatment, not just more medical treatment, which tends to drive delay and costs over time. So, all of our organizations have been looking closely at SB 863 and how it's being implemented. WCAN mounted what we called our 14 by 14 effort because we wanted to ensure that measures that the legislature had been assured would offset that higher benefit cost would actually come to fruition. What we witnessed is sort of the left side of the screen here. What we witnessed on balance is a dedicated effort by those folks responsible for implementing the regulations to get the bill implemented. There's still some things that are underway, that are in process. Not everything is panning out exactly as envisioned, either in sort of the mechanics of it or what it's doing in terms of performance from a cost perspective. But again, the big takeaway I think on balance is we have seen a dedicated effort, a commitment to get those provisions implemented as quickly as practicable. We see three challenges, and we've been talking about these for a while. The first, obviously, is the independent medical review system, which is being utilized significantly more than initially projected or thought. Here we show that the amount of IMR requests come in were about 3 times what was projected. There's some newer numbers that have come out recently, but even if you strip out those IMR requests that have been deemed either duplicates or ineligible, you still see that the amount of IMRs is at least double. We're getting about 60,000 of these per quarter. And because of that high volume, the Workers' Comp Insurance Rating Bureau revised the projections that it made some time ago, and it really about cut those projected cost savings in half from IMR because they don't see any reduction in the amount of temporary disability benefits because we're not getting to resolution faster at this point, and we're also not seeing any reduction in the frictional costs. Sort of on the other hand, the Division of Workers' Compensation did just publish a report last week saying that it felt it had made some progress in working with the vendor, which is Maximus, in getting up to speed, clearing out the backlog, getting the IMR system to perform more quickly, which hopefully over time will make it the resolution of medical disputes more efficient going forward. The other big problem in any reform, and SB 863 is no exception, is litigation. And we see a number of these, whether it's respect to the lien reforms or the IMR process. Any of these, if they really strike a heart at one of these reforms, could upend the cost projections for SB 863 and really prevent that reform package from making the system changes that the legislature had intended. And then the last item on the watch list for SB 863 is sort of back on this issue of claim frequency. Again, if we're paying higher benefits, but we're paying it to more people than we thought, that's again going to upend the balance that was envisioned for SB 863 from a cost offset perspective. When the bill was scored, the Bureau initially said they thought about a 1% increase in frequency. Well, right out of the gate, after that bill was passed, we were up around 5%. That's been brought down a little bit, but it's still much higher than projected. So,
this is Jason. I want to offer one observation about this slide. I think the main takeaway from SB 863 and frankly past reforms is when we're doing this kind of balancing act with legislation on workers' comp, you've got the benefits side, which is a pretty straight line transaction. We know how those dollars are going to come through. We know how the benefits are being utilized. We may be off on the increase in frequency or the increase, in use of the benefit because of the increase, but we know basically what it's going to cost. When we score these savings provisions, what we need to remember is that there are 1,000 decision points between passage of the bill and full implementation of the bill, whether it's IMR, UR, MPNs. There's a bunch of decisions between passage and implementation that frankly impact the net savings. And so what we need to aim for when we do these bills is overshooting on the savings, because at least in every reform package that I can remember, we've come in under what we've expected. So, when we're looking at the big picture for these bills in the future, what we really want to do is try to get this kind of 2-to-1 savings to benefits, because we almost always slide. And it's not anybody's fault. It just is what it is. You've got COG going after the reforms in litigation. You have disputes over implementation and what's best for the system. and it just never works out the way we quite thought it was going to.
And here's, a more academic by the numbers look from the Workers' Comp Insurance Rating Bureau that sort of just published its second retrospective look at SB 863. Again, the numbers in workers' comp world are still fairly new and green because it takes a long time for trends to develop and become clear. But as you can see, there's a lot of yellow, which is where things are coming in about where they thought. There's some green where provisions are saving a little bit more, but there's also a fair amount of red, which is where provisions are not performing up to where the Bureau initially projected that they would be. So, in the aggregate, we're, about 200, maybe 200 million to the good on liens because it's outperformed projections, but we're also 200 plus million to the bad on the IMR reforms. So, where the rubber meets the road for most employers is what am I going to pay for my workers' comp insurance, particularly for the majority of the employers in California who purchase insurance. And as we can see, since 2009, rates have gone up about 40%. We're still not as high as we've been historically, but it is going up, particularly at a difficult time for employers in California. And as we can see, 2012 and the reforms that were enacted did not either halt or reverse those cost increases. In fact, the insurance commissioner recently published an advisory pure premium rate, which was an additional 6.6% next January. So the cost growth continues. But what the conclusion from some stakeholders is that SB 863 kind of, again, at its heart was not intended to arrest or halt or reverse that. It was really meant to stem the growth. The DWC over the summer concluded that SB 863 had maybe trimmed about 3 percentage points off what the increase would have been. So still an increase, but perhaps not quite as much, at least according to the Division of Workers' Compensation. So, we're mostly in a wait and see. Again, there's still reforms to be implemented. There's still issues to be litigated, and we still need to see how a lot of the SB 863 provisions perform over time in the real world of California's workers' comp system. So again, we think all that's an important stage setter as we look ahead to next year and sort of how these issues get debated in the state legislature.
So we're going to dive back into the legislature, looking at bills from last year and potential legislation in the next year or two. But before we do that, I did want to we've gotten one common question so far about if these slides will be available. They will be. They'll be posted to the CCWC website, as will this entire webinar. So go to the website after the conclusion, and you can get all of the slides there.
Okay, so running into the bills from last year, and this is partially just to give you a little bit of an understanding of what to expect going forward. AB 1035 by former Speaker John Perez on peace officer death benefits. This is a bill that essentially extended the statute of limitations for some peace officers on some claims. It's not every peace officer, it's not every claim. It's specific to those peace officers that had injuries that fit into presumption statutes. So you're looking at cancer, heart, and other claims. And the idea was, from the labor perspective, that medical treatment is keeping folks alive longer, and that the 5-year statute of limitations on death benefits was almost punishing injured workers for staying alive too long. So there was a healthy debate over this bill. Ultimately, it was sent to the governor, and he made the decision to go ahead and sign it. And I can tell you, this is the only bill in 4 years that he signed kind of over the objections of the employer community. So, while it wasn't something that we were excited about, it certainly wasn't the end of the world.
The next bill is AB 1746 by Assembly Member Luis Alejo, and it provides or expedites hearings for unrepresented injured workers of illegally uninsured employers. It does this so they can basically jump to the front of the line procedurally and get quicker access to the uninsured employer benefit trust fund. They need a WCAB judge to declare them eligible for that, and then they can start receiving timely benefits. This bill received bipartisan support from employers, labor, applicant attorneys, and ultimately was around for both years of the last session, but ended up passing out last year and was signed by Governor Brown.
Next on the list, AB 2052, and you're gonna start to notice a trend here. Labor has in large part stayed out of nuts and bolts workers' comp issues for the past several years in an effort to kind of honor the deal that was struck with SB 863. Frankly, where that falls apart is on public sector presumption bills. So you're going to see, 4 bills aimed at the public sector: cities, counties, special districts, JPAs, et cetera. This one was pretty rough. The bill basically took a specific section or sections of the penal code and said, every peace officer that is identified or described in that section is now eligible essentially for all of the presumptions offered to other peace officers. It was a pretty substantial expansion in the tens of thousands of officers that would be eligible. It was certainly a high-cost item for cities, counties, et cetera, but also for the state. It had a very high price tag. And so it did end up going to the governor. Cops and firefighters are pretty politically popular here in the state of California. It got bipartisan support. But it got to the governor, and he essentially said, that he didn't see any evidence behind this, and therefore wouldn't sign the bill. So that was good news. Excuse me. The next bill is AB 2378. This is basically dealing with the interplay between the TD cap and 4850 time for peace officers. There was some case law that brought the whole issue into question. Frankly, there was a couple cases over several years, but there was this question of should 4850 time be included inside of the 104-week cap on benefits. Labor obviously thought no, peace officers deserve a full year of salary continuation and then 2 additional years of temporary disability. I think employers took the perspective that, well, there's no evidence to indicate that cops need or firefighters need, based on their injury mix, more time. Let's look at the data. It got to the governor, and the governor agreed with the employer community and said, essentially, there's no data here. Demonstrate that this additional time is needed, and maybe we can have a conversation about it.
Next bill is AB 2604 by Assemblymember Brown. This bill attempted to bring back certain Labor Code 5814 penalties. 5814 penalties is kind of the buzzword that was known pre-2004 reforms. There were penalties that were often gamed, slapped onto claims where the penalty portion of the claim lacked merit and were used to spur litigation and increase settlements. CalChamber labeled, this is one of the bills we labeled a job killer, and we worked with coalition partners like CCWC and a large percentage of a number of members from the employer and insurer community. We were successful in preventing this bill from getting a hearing, so it ultimately died in the Assembly Insurance Committee. However, Jason just hit on recurring themes that you'll likely see on a go-forward basis, and I think penalties in general are an evergreen issue in workers' comp, at least penalties for employers and insurers, and I think you will see them return in some form or fashion next year.
AB 2616 by Assemblymember Skinner. This is a bill that has been run through the legislature, I want to say almost half a dozen times at this point. It creates a presumption for acute care hospital workers with direct patient contact for MRSA. Now, previous versions of this bill didn't just include MRSA, but included other bloodborne pathogens, included a neck and back presumption for these types of hospital workers. We've fought over this bill for years and years and years, and one thing that I'm really happy about is that it seemed like the governor slammed the door pretty hard on this bill in his veto message, and specifically said that he wasn't ready to go down the path of providing presumptions in the private sector. which is something that we've been saying certainly at CCWC and the Chamber and WCAN for quite a while. So we were happy to see that reflected in his messaging.
Next bill is SB 626 by Senator Jim Bell. This bill actually came up in 2013 and made a brief reappearance last year in 2014. And it did a number of things, but at its heart, it repealed some of the cost-saving provisions of SB 863. It was a rollback bill. In particular, it stymied IMR. It would have put essentially medical dispute decisions back in the hand of judges instead of doctors. Again, it had a number of other things in it. It kind of turned into a Christmas tree bill where everything was hung in it. And we were able to kill this bill twice, or at least stop it from getting a hearing both in 2013 and 2014. But again, I think that you will see legislation attempting to roll back saving provisions of SB 863 in the next year, although I don't think you'll see any rolling back the other half of the deal, which were the benefit increases.
So finally, there's SB 1234 by Senator Block. This was a bill that basically did what the other bill on presumptions did, which was identify a section in the penal code and say every peace officer there is eligible now for 4850 time. So you had broad expansion of both 4850 time and presumption bills in the legislature last year. Luckily, this one died in the legislature and didn't really have a chance to see the light of day. But again, this is something that you're going to see going forward. This is easy politics for the unions that represent cops and firefighters. They get to go in, they get to talk about the brave things that those folks do and some of the dangers they face on the job, and make a case, to legislators about why they need more than the average injured worker. So you can expect this to continue in perpetuity.
So looking at next year, I think we kind of see some general themes we think are going to arise. Some are old, some are a little bit newer. Well, the first thing, though, is finishing SB 863 implementation. And Jerry touched on in his chart what's left, depending on how you define the kind of big areas of regulation. There's 10 or 11 of 14 areas that have been completely implemented, but we still have a few outstanding, including some fee schedules in areas like coffee service and home health, and then the return to work fund as well needs full implementation. But certainly a lot of efforts in the comp policy arena will be focused towards finishing off SB 863 implementation.
So broadly speaking is going to be the issue of medical control. And everything, both the pharmacy formulary, UR, IMR, MTUS, MPN, this all goes into the same category. There's a broad conversation occurring. California applicant attorneys are doing their best to make issues out of UR, IMR, and just medical care in general. But they very much want to undermine utilization review and independent medical review. Frankly, from the perspective of some folks in the applicant attorney world, they would much rather have had the judges, making medical decisions as opposed to doctors. I think from the employer perspective, what we really want to see is, the interplay between MPNs, UR, the MTUS, IMR. We need to see all of those things kind of really gel and get rid of some of the cracks and fissures that are in that process that allow for inefficiencies in the system, a high number of IMRs. If you look at the pharmacy formulary bullet point, the reason that's coming up is because, as we mentioned earlier, IMRs are obviously way out of whack as far as the number that were expected. So I think there's a feeling that if we were to do a pharmacy formulary like they have in group health, some of those disputes would, go away. Now, there's a question: if that's done through regulations as part of the MTUS, are physicians and applicant attorneys still going to be able to send that to IMR? Is that really going to decrease the number of IMRs? Maybe it does. Maybe it doesn't. Maybe it does, but not to the extent expected. These are all things that are swirling about. How do we take all of these tools that have been provided over the past, decade plus, and really kind of fit them into a tight puzzle where they all serve the function that they are intended to serve. And frankly, on the other side, the applicant attorneys are doing their best to stop that from happening and to identify these as system liabilities instead of system tools. And really, from at least the CCWC perspective, kind of pervert the nature of these tools and make them negatives as opposed to positives. We're working obviously in the opposite direction. So expect a big conversation on medical control, pharmacy, and all of these topics in the coming year.
The cumulative trauma point, I don't know that we'll see any kind of legislation on that next year. But it is, as Jerry indicated when he was going over the system slides, that California is an outlier when it comes to cumulative trauma. And it's certainly a conversation that employers want to continue to have as far as what issues do exist within that realm and are there thoughtful solutions. So I wouldn't expect any legislation, but again, an ongoing dialogue on the subject. I covered already the more claims administration penalties. We see these introduced often. My guess is you'll see them again next year. I think we need to really take a look at what the data suggests are system-wide issues. Certainly, we wish the system was always perfect. Sometimes it's not. There are already a fairly robust penalty scheme within the workers' compensation system for employers and insurers anyway. And so these are things that you see often in legislation, and I'm guessing we'll see again.
And as we indicated, presumption policy will continue to charge ahead. Political takeaways. I think one thing we can be relatively sure of is that Governor Brown will continue to promote relative and general stability in the workers' comp system. Like we said, he's been near perfect from our perspective on signatures and vetoes. He's taken, in the big picture, a path towards stability. The legislature, I think, to a certain degree, has a different perspective on the matter. They send, in our perspective, from our perspective, a lot of bad bills to the legislature. They're going to continue to do that. There's a tendency sometimes in all legislatures, not just this, but to send bills to the governor when you know he will veto them, right? You don't have to necessarily make the tough decision because you're relatively sure that the governor is going to veto what you consider to be a bad bill anyway. So in a state like California with a lot of labor support, a lot of labor power, frankly, Democrats don't want to be in a position of rubbing up against them on some of these bills. And why would they when they know that the governor is going to kill the bill anyway? So I think there's some of that going on. So most of these workers' comp bills are going to continue to survive the process. Where we feel like we really have an outlier, a problem bill, we're of course going to do what we need to do to kill it early, as we kind of talked about earlier. And part of the way we do that is there's a great block of moderate Democrats in the Assembly and some in the Senate that can engage on the issue from time to time, and we'll continue to do that. California employers, I think a takeaway is, you guys need to continue to be absolutely engaged and educated. There's lots of opportunities to do that. But, the applicant attorneys are up here every year. Labor comes up every year. Everybody's very, very interested in pushing their own perspective, and you folks need to be in that same camp.
Yeah, I would underscore that again. There's a lot of education opportunity. Jason talked about the new members, but if you look at over half the legislature is either in its first or second term, and work comp usually is not a knowledge base they bring with them up here, and so there's a lot of opportunity, particularly with the shift in term limits, to educate members that will be in similar roles or their same roles going forward for potentially the next decade.
Right.
Well, the corollary to what it is that other stakeholder groups are going to try to do in the legislature is that employers need to do the same, and that means keeping yourself informed so we can identify issues early, not only coming from organizations in Sacramento, but the two-way feedback is really important of issues that are identified in your discrete industry, at your specific company, specific locations in the state, helping the advocacy sort of apparatus, as it were, identify issues that are on the ground is really important. So to the extent that you have information to share, we encourage people to do that frequently so that it's not all just sort of top-down 30,000-foot information that we're hearing, but hearing direct experience as well. There's a number of ways you can do that. Jason talked about the conference that occurs in the summer. WCAN and Chamber both put out regular communications through our email distribution list. Staying engaged is really important as well. We do have the Legislative Education Day, or the Lobby Day, here in Sacramento that we encourage people to think about. It tends to be in the spring. The specific date revolves around when the legislature sort of plans its spring recess. But there are other ways to get engaged locally, building a relationship with your assembly or Senate representative, even local government individuals that may have something to say about employment in your area. Engaging on a grassroots level when specific bills or calls to action come up, or even on specific regulations when things need to be supported strongly or opposed strongly. The ability to marshal our collective voice becomes very, very important. And social media is another way to keep connected and engaged, where in between those newsletters and in between those conferences and conference calls, a lot plays out on social media, getting information, having dialogue, getting in the same information loop. So there's a variety of ways, and then you can always just pick up the phone and always call any of our organizations or ask for us to come make a presentation to your local business group or industry group. We're always happy to go on the road and do that to get the word out. And all these websites are available to, fairly consistent but probably a little bit different information on all of our websites about the workers' comp system. So with that takes us to the end of our webinar. And sorry we went over by just a few minutes here, but hopefully everyone was able to hang with us, and this was informative and helpful as we wrap up 2014.
Again, the slides will be available on the CCWC website. Jerry, are they going to be on the WCAN website?
They will also be on the WCAN website as well.
Great. And then just one correction, ccwcworkcomp.org, not com. My apologies. Thanks, everybody.
Thank you.